Hello again, hope you're all doing well. Today, I'm just the messenger. My channel explains the law as it is, not as maybe some of you want it to be. Today's issue is definitely one many take, or at least a few of you take, very personally, judicial bias. When it gets that personal, it's really critical that I stay as close to the case law as I can. So feel free to take some notes, or you can just stalk the channel and just kind of come back to this video whenever you need to. And as a general thank you for sticking this one out, if you stay to the end, there's going to be some information on how to download that latest case law roundup that I just made, so hang tight. Now, as most of you know, I do appeals. That is a very different world than trial practice. Most of the time, if the trial lawyer didn't even bother with an SOJ or a Rule 65 request, and more importantly, went so far as to try to get a ruling on that, there's really nothing an appeal arguing judicial bias can do because the issue is generally forfeited. Forfeited is the fancy word the appellate court uses to say, you failed to raise this issue at trial. Because you have to remember, appellate courts are a court of review. In English, this means they're a court of repeat. You repeat your argument to the trial judge. Hey, judge, the law says you have to do this. If that fails, you repeat it before the appellate court. If they agree the judge made the wrong call, well, they usually reverse. But, and there's always a but, an exception exists when the alleged bias in this instance were to arise at trial, because at that point, it's too late for anyone to file anything. The horse is just kind of out of the barn, which is why today's case was picked, because as the decision admits, there's just not a lot of case law pertaining to judicial bias that arose during the trial. The best we have are these two non-family law cases, and they're also cited in today's decision. Now, let's be a little frank here. If you are a family law attorney and you haven't had a judge go off on you at least once in your practice, you have to be living a charmed life, because I think it's just going to happen. Sometimes because you or your client did something stupid, or sometimes because the judge is human and they're not really having a great day. But usually after the ash chewing is done, that's the end of it. But let's say that's not the end of it. At what point do we go from saying the judge is expressing frustration to the judge's comments make it clear they intend to throw my client under the bus? Facts be damned. And that's where today's case comes in. You know, that's where Dad says, hey, appellate court, I brought a court reporter and look at all these terrible things that the judge said about me. And that's my proof the trial was rigged. Now, the appellate court, to Dad's credit here, admits the judge could have used a softer tone. And these quotes are straight from the opinion. As always, read the case before jumping to any conclusions, because in the judge's defense, most, if not all, these instances fell on the heels of Dad apparently thumbing his nose repeatedly at the trial court's order. But let's say, for the sake of argument, even if the comments were prima facie way out of line, the appellate court holds that there's more a party has to show in order to get some help from them. Namely, you must show where the court's bias impacted the outcome of the case, aside from hurt feelings. Here, the court points to a couple rulings where the judge could have legally crucified the husband. In one instance, the judge could have actually incarcerated him for violating a court order, but at the sanction portion elected not to go that far. And on another occasion, the court actually agreed with Dad's arguments on a particular issue. So in their view, the record doesn't establish, I guess, the fix was in, regardless of the court's comments. So it seems, and this is merely my reading, that if you are arguing judicial bias based on trial court proceedings, the appellate court is really looking for mean things to be said or done, plus a nearly asymmetrical outcome that is not supported by the record. So here, Dad was able to show the first part, highlighting statements by the court, but wasn't able to show where in the record the judge's displeasure unfairly impacted the outcome. So the judgment is affirmed. So as I noted, there's no handout for this case, but since you stuck around till the end, I do have a dissipation guide. Surprise! It's got a list of featured cases, previews of where you can find them and what they're about, some basic 101 law for new lawyers. Of course, it has citations to the record, basically all the good stuff. You can download it this evening on the Substack, probably around 6 p.m., maybe later. Who knows? Now, before I go, this small channel exists because you came here. Like the practice of law, it's always a privilege and never a right. So, thank you, and until next time, as always, thanks for watching.